Yes, sir, Mr. Shea. Good morning.
Good morning. Richard Shea for the appellant, John Petetabella. At the outset, I have to acknowledge there's a large number of issues, and each of them seems to have a multiple choice with it as to the standard of review and retroactivity of the law, which has developed in the 46 years since this case was tried. I think the logical starting point is the first issue in the brief, which is whether the defendant's failure to notice an appeal back in 1964 was due to ineffective assistance of counsel. If it was,
but hasn't that been decided adversely to you because of the motion judge's findings? He did not find the defendant's affidavit credible or evidence.
Yeah. He basically what he found not credible was essentially the defendant's testimony that he had been told by his trial attorney right after trial that he could not appeal because he had gotten on the stand and admitted his participation in the crime. The judge discounted that, so whatever Petetabella said.
Putting aside that, what possibly could he have won if he had appealed it and had the verdict vacated?
He could raise the issues of insanity and
right. Let's assume he actually does that, and let's assume he actually, for some reason, the SJC then said you get a new trial. He still has his testimony where he admitted it. He still is going to be at risk of being convicted again.
Yes.
And doesn't he face the risk then that he would be given the death penalty based on the law at that time?
That is largely what the motion judge based his conclusions on. What I'm conceding on the findings issue that Justice Cowan started out asking was that the findings that are entitled to deference are only as to Petetabella's testimony at the hearing. The rest of it is a printed trial record, which this court under the case law can review on the same standard as the motion judge. That said, my position on the death penalty issue is the case law that this court has developed, starting with Commonwealth versus Frank and Commonwealth versus Goldman, is that ineffective assistance of counsel, waiver of an attorney's conflict of interest has to be based upon knowing and voluntary waiver.
So waiver
in this case,
conflict
of interest. Did you bring up anything about a conflict of interest in your brief? What conflict of interest?
Well, the conflict of interest was that he was the trial attorney who was recommending on appeal. Under this court's precedent, there's a conflict of interest where the attorney is giving advice based upon his own performance at the trial, where there may have been an issue to be raised on appeal. In this case, there's at least one issue of ineffective assistance of counsel that was clearly apparent at the time, and that was the exclusion of women from the jury, which he failed to object when the trial judge explicitly stated he was not putting any single women on the jury.
I have a question. It's not clear from the record. Were there 12 jurors? How many jurors were seated when the judge said, made the comment about women not being on the jury?
I believe there were 12 seated, and they were seating a 13th.
Or was it there were 13 seated and they were seating a 14th?
No, I think,
There were only 13 who ultimately sat.
Because 13
the judge
sat.
just gave up. They gave up at the end of trying to find a 14th.
Right. Well, that's what I'm trying to find out. Was another person picked after the judge made that statement?
I believe it was a male that was picked after he made the statement, yes.
And was, when the jury was reduced, was the alternate the 13th juror, or was that alternate chosen by lot? Do you know?
I don't recall at this point. I can submit a letter on that.
Well, one question.
Going back to the issue that you got sidetracked on, 1964. Let's assume he has Clarence Darrow as his appellate attorney. Is Clarence Darrow? He wasn't alive in '64, but let's assume he had the equivalent. Is he going to say to him, if you win, you still face the risk of having the death penalty upon a retrial? Is that the prevailing case law in '64?
My argument is that it was not clear under SJC precedent at that point that would be the case, that there was precedent from outside the Commonwealth, notably People versus Henderson from California the year before in '63, which was based on a Frankfurter dissent in Green versus United States, which said that this was an unconstitutional burden upon the defendant's right of appeal for him to have to risk death in order to take the appeal. And that ultimately, we had the Supreme Court came down with 1972, I think. Maybe
But
it
that was
69,
after this case.
North Carolina versus
But that was
Pierce.
after this case.
Well, it was, but
But the lawyer has to give the advice based on the law at the time of the trial and possible appeal.
Well, I also make the, I'm not sure that is so clear under the.
What, the lawyer's advice has to be based upon law that hasn't developed yet?
Well, the client's, my argument is not so much looking at the attorney's subjective state of mind as a legal matter, as that People versus Henderson case suggested. The waiver of the right to appeal can't be voluntary if it's being imposed by the threat of the death penalty. And North Carolina versus Pierce, which came down, I think it was '69, said you can't impose a higher penalty on somebody.
Again, after the trial.
Yes, but he should have been counseled that he had this precedent in his favor.
Not precedent,
Well-
future cases.
Well, I think this court also has to be looking at the voluntariness of the waiver from you can look at it from a retroactive standpoint, based on the arguments that fall later in the brief, that the development of fundamental trial rights can be applied retroactively, and here it could be applied retroactively to vitiate the voluntariness of his waiver in 1964, because it was based on unconstitutional law that can be seen today to have been unconstitutional.
I just sort of have one fact. Apparently, the attorney objected on the record to the defendant's taking the stand. Is that true?
Yes.
So, but yet the defendant, well, doesn't that's on the record, so that's no dispute to that.
Yes.
And doesn't the defendant at some point counteract that, say that his attorney insisted he take the stand?
Yes.
Well, then doesn't that make his affidavit suspect from the beginning? Because it's contradicted by the record in which which shows that the attorney objected to taking the stand, and the judge instructed him, warned him that he was taking the stand against his attorney's advice.
The defendant.
And then he came.
The defendant's testimony concerning his waiver of his appeal was discredited by the trial judge. And yes, I accept that was discredited. He said, I didn't take the appeal because my attorney told me I could not. The judge said, I don't believe it. Fine, that's clearly erroneous standard. What I'm saying is that everything else is really a matter of law for the court to look at the whole case and determine whether objectively the defendant in this situation, with this state of the law, with the defenses that could have been raised on appeal, did knowingly and voluntarily waive his right to appeal. And I want to add that I came up belatedly somewhat, and I argued my first memorandum of law in the trial court that this was under Franks and Ebbets versus Lucy, Supreme Court decisions from the 1980s. The Commonwealth came back with their reply memorandum to the trial court citing Roe Ortega from the Supreme Court, which seems to set up a higher threshold for a defendant under 14th Amendment to show that his right to counsel was violated in waiving an appeal. So I raised it at the argument in the trial court, and in my reply memorandum, I was also raising this issue under Article 12 of the Massachusetts Declaration of Rights. As far as I can see under the case law, this court hasn't had the opportunity to consider this issue separately from Supreme Court precedent. I maintain that this, the Article 12 standard should be based on Commonwealth versus Alvarez, which I stated in my brief, which sets a fairly high standard for knowing and voluntary waiver.
If we should conclude, contrary to what you've just been arguing, that the defendant waived his appeal,
yes,
originally, do you agree that this would not be his direct appeal but a collateral attack because he waived the appeal? If we conclude
that's what the case law sets down as the ABCs of case law. That is correct. The only qualification I'd make is that this is a 278 Section 33E case because
no, not now. Not now.
Not if it's a collateral
Not
attack.
if it's a collateral attack. It's not.
He's.
That's the distinction. That's why I asked you the question.
My reading of it, this case fits within 278-33E.
Only if it's his direct appeal. But if he's waived his direct appeal, and now this is an appeal from the denial of a motion for a new trial.
It may fit within the statute in terms of the sort of gatekeeper thing, but it doesn't mean that the what we think of as Section 33E review applies to it. Isn't that what you mean?
Well, I just have to refer the court back to the language of Section 33E, which when I read it, this fits within it. And the distinction is that he hasn't had an appeal. He doesn't have to go to a gatekeeper because he hasn't had this court give him the plenary review. So I read the statute as saying he still has the right to plenary review. In any event, what it comes up as is substantial likelihood of miscarriage of justice. The only issue I think that applies to is the failure to object to the seating women on the jury, because I argue that was clearly set out in Supreme Court precedent before 1964. Otherwise, we get it to the problem of, yes, it may be a collateral review, but are these constitutional issues that have developed, particularly the ones relating to the jury instructions, which I've tried to emphasize in my reply brief, are they going to be applied retroactively? And if they were not, if counsel had to be clairvoyant in '64 to recognize these issues, and he would have had to be, then his failure to object can be excused. And then the question is whether the later developed law is retroactive. And I've tried to make the argument in my briefs that this falls within Commonwealth versus Medina, which has recognized that all of these burden-shifting instructions that are objected to are to be applied retroactively because they're fundamental due process
But we've said that
issues.
we've adopted Teague, and Teague says that if it's in essence, in short, a fundamental error that really affects the proceedings, then it's to be applied retroactively.
But the court's statement about that came in Commonwealth versus Bray, which was right after the Teague decision, which was back in '89, I believe. The case I'm relying on came in 2000 in Medina, in which the court made it very clear that the Sandstrom kind of errors are to be applied retroactively.
But we didn't discuss Teague in Medina at all.
No, but you also decided the Amirault case in the collateral review of Amirault in '97, I believe it was, and dealt with the right to personally confront witnesses, and that was held to be a fundamental fundamental constitutional right under the Teague analogy. I don't know that Teague was actually addressed, but it was applied retroactively.
But
you've got two cases that, and this court doesn't have to. You have Teague, And
Which we've
what
adopted.
what the Commonwealth is relying on is lower federal court authority. Since then, the majority of the cases having said that these Sandstrom errors are not retroactive. But this court is also not bound by Teague. And the Supreme Court made that clear in Danforth versus Minnesota, that the state courts can go off and develop their own standards of retroactivity. And I think it's important to point out that the reason for that is that the federal standard, the Teague standard, came up in habeas corpus, which involves a lot of federal court deference to state courts. And that's not present here where the state court is reviewing its own
The Commonwealth
convictions.
argues that we have, in Bray, we did adopt Teague.
Said you'd follow Teague, but what is Teague was Teague didn't say that Sandstrom's not retroactive.
Speaking of Sandstrom, he was found guilty of first degree under what theories?
Sandstrom versus
No, in this case.
Petetabella?
Yeah, was he found
It was-
guilty of felony murder
All-
as well
all
as
three.
all
It was
three?
instructed on all three,
And found guilty
they
of all
gave
three?
a general verdict of guilty.
So we don't know which of the theories the jury chose.
No, we don't.
These were
And,
these were the good old days where they didn't delineate what the
No.
theories were.
But most of the cases have concluded, most of the federal cases have concluded that Sandstrom is not within one of the Teague exceptions, and therefore not retroactive as a matter of federal law. And we've
Yes.
adopted Teague.
But you've also decided Medina. And
But Medina didn't discuss Sandstrom.
Medina, yes, it did apply Sandstrom retroactively.
Yes, but that, I'm sorry, without any
Medina's right.
discussion of Teague.
Yes.
Right, and, okay.
But this court isn't bound by, if the
No.
federal appellate courts go off in one direction, which I'm saying,
correct.
one of the reasons they're going off that way is because they're dealing with habeas, interfering with state proceedings, that they might set a higher threshold under Teague than the state court has to when it's deciding its own retroactivity. And you can also apply retroactivity under Article 12. Again, that's I don't know that that has been addressed by this court as diverting from Teague.
Even if we adopted your approach and we said that we were going to apply Sandstrom retroactively in the defendant's favor, is it harmless error because nobody can fairly look at these words and say that they affected this jury?
Well, I maintain I've tried to make the point, one, that these words appear in three distinct parts of the jury instructions, and they should be considered together, and they affect the jury's consideration of insanity and intoxication as it affected his intent.
But there was very strong evidence, even including after the fact, when I think, did he dispose of the weapon? He was acting even after the crime, immediately after, to cover up.
That may be true.
And there was clear evidence beforehand that it was planned out.
The standard is harmless beyond a reasonable doubt, and this court says in Commonwealth versus Roberio, which I've cited, when you've got a psychiatric expert who testifies that the defendant is not competent, as he testified in this case, because he could not control his impulses under the McCool standard, that's as far as you can go. You've got the evidence. You can't say that that's harmless beyond a reasonable doubt because the jury might have believed other aspects of the case. And again, what we're dealing with is burden shifting and presumptions that the jury might not have even had to consider the psychiatric opinion if it took the presumption, the mandatory presumption language, which occurred twice in this case, literally, and said, well, he did what he did, so he intended to do it.
Mr. Shea, how old is the defendant now?
I think he's about 67.
And how many years has he been incarcerated?
40. Well, he was arrested right after the crime, which was 46 years ago at the end of this month.
Okay.
The presumption language that you focused on, is it the presumption that one intends the natural consequence of one's acts? Is that, or
Yes.
or is that?
There's two that I quote.
Because with regard to felony murder, it doesn't much matter whether he intended the death. If it's a death during the course of an armed robbery,
The robbery has, as an element of the crime, larceny, which requires intent permanently to deprive the victim of property. And in this case, the intent instruction, the burden shifting would go to that intent issue as well. And then, of course, there's the intent to kill and the other malice aforethought that's in the other theories of first-degree murder.
Mr. Shea, your time is up.
Thank you.
May it please the Court, Rachel Eisenhower for the Commonwealth.
May I ask you right off the bat about this 14th juror? Was another juror seated after the judge made the improper remark about no women on the jury?
Until you had asked the question, I strongly remembered that no other juror had been impaneled afterwards. I still believe that to be the case. I believe that...
Okay, how can... All right, well, I suppose we'll find it out by reading the record, right?
Yes.
Okay, because that could be very important.
But my understanding is that 13 men were seated fortuitously, and in fact, that you could read that from the judge's comment. His initial plan was to seat 14, and he said, "You won't want just one, will you?" It was immediately after the seating of the 13th juror. Had it been after the seating of 12th, he wouldn't have been concerned about a single female.
Well, that's why I was confused, because it wasn't clear. I couldn't align the judge's remarks with everything that was said in the brief. So, okay, so we'll just have to look at the record to discern that.
And do you know how the alternate was chosen?
I do not know how the alternate was chosen. I don't recall if it was the 13th, the actual 13th juror or not. But
Sorry. Can you address this Medina
Yeah, I was gonna
Sandstrom?
ask that.
yes. So in the early 1980s, the Supreme Judicial Court determined under a pre-Teague retroactivity standard, I believe Linkletter was the pre-Teague retroactivity standard, and under that standard, the SJC decided that Sandstrom versus Montana would be retroactive. Later, in 1990, unrelated to anything to do with Sandstrom, this court adopted a general retroactivity standard.
In Bray?
In Bray. And the standard that they adopted was that announced by the Supreme Court in Teague in 1989. They made no limitations of what it was going to apply to. The SJC made no statement about whether it would apply only to cases whose retroactivity had already been determined or only to new rules commencing after that date. Rather, it just announced it as the new retroactivity standard. Several years later, another Sandstrom error was raised, and this court, citing directly back to the early 80s case law that seemed directly on point, said Sandstrom is retroactive because of those early 1980s cases. Now, no party ever raised in those cases the issue that a general retroactivity standard had been adopted.
Is that Medina, the case you've just been...
I believe there was one earlier than Medina, but certainly Medina is an example of that. I believe Arsenault may have actually had that issue, or Amaralt may have actually had that issue too, but definitely Medina is an example of that. So Medina reached right back to the early 1980s, notwithstanding the fact that the seemingly on-point case could have been overruled by Bray, depending on the intent of the SJC in adopting Bray.
Mm-hmm. What case are you suggesting could have been overruled?
The one that Medina reached back to...
Linkletter, or was it something
No,
else?
Linkletter is the
one
federal...
based on Linkletter. The one that adopted Linkletter. Yeah.
No, the SJC case, you're right.
The SJC case from, I believe it's 1982 on Sandstrom. Is it Raposa? No, that's 1986. Yes, I believe it's Raposa,
It is
1987. Okay, 1982, not 1987, but in either case, prior to the adoption of Bray. So it is an open question of law in this jurisdiction whether the court intends that all cases have their retroactivity decided by the Teague standard, or whether Teague was only intended to be adopted for decisions where retroactivity had not already been determined as to the case.
Wait, say the last part again. Was Teague intended to be adopted for what?
For all decisions going retroactively, or was it merely a rule for things that had not been decided yet?
For issues. So
For issues
in other
that
words,
is not.
Sandstrom would not be covered under the latter theory.
Under the latter theory, Sandstrom would not be covered because the SJC had made a decision in 87, and the 1990 Bray decision under that theory would not be intended to displace the 1987 decision as to the retroactivity of Sandstrom v. Montana. But Bray makes no note of whether it is intended that way or not. So that's an open question for this court. There are, as my brother pointed out, there are no federalism constraints because several years ago, I believe 2007 or 2008, the Supreme Court decided in Danforth versus Minnesota that the state Supreme Courts were not bound by federal decisions on the matter and that they could use Teague in any way they want as it was convenient for their own state retroactivity issues.
It was a floor, but not
Is a floor but not a ceiling, exactly.
If we were to adopt Teague, as you suggest, and apply it so that Sandstrom is not retroactive, what about those cases in which we've already held that Sandstrom was retroactive?
In those cases, the defendant has had a fortuitous benefit as a result of the fact that the Commonwealth did not raise the issue about the conflict in law, and that's been a fortuitous benefit to those defendants. But as the Commonwealth has no liberty interests certainly at stake in the trials, so it would be more of a concern when things go the other way. But
Okay, and what do you say to the defendant's argument that if this 14th juror, that we can't conclude here that the burden shifting language was not harmless error?
His argument actually has a lot of support in current SJC case law because the SJC has said that previously the only cases that have been found harmless beyond a reasonable doubt are those in which the issue has truly not been raised. So cases in which the only issue was one of identity. Even the defendant acknowledged that the murderer himself, whoever it was, intended to kill this person, but intent was not in dispute, identity was in dispute, and therefore the presumption language in an intent instruction clearly had no effect. I'm suggesting that in addition to those situations, this case presents a limited factual situation in which the court can similarly conclude that it was harmless beyond a reasonable doubt. And that limited factual situation is this. Even though sanity was in dispute, and thus implicates the presumption error here, the defendant himself took the stand, and his own testimony almost directs a verdict against this theory that he's arguing, notwithstanding the testimony of his expert, who did, in fact, testify that he actually uses Chief Justice Shaw's standard for insanity from Commonwealth versus, I believe it's Rogers, but that the irresistible impulse standard is what it is, that notwithstanding the fact that he knows the difference between right and wrong, he is unable to control his conduct, that he is overwhelmed by the disease and renders him incapable of resisting and controlling an impulse, which leads to the commission of a homicide. But the defendant's own testimony is inconsistent with impulse. The whole chain of events that he testifies to is not an impulsive act. It is a planned act. And the issue, of course, is in my opinion, the conduct of the certainly for the felony murder, it's the conduct of the entire robbery. Since there are the other two alternate theories that the jury was charged on, premeditation and the other, then that impulse has to go to the shooting as well. But clearly, throughout this entire event, he has been planning, he has been disposing of the evidence. There's one point he gives a direction to the others on how to dispose of the evidence. He tells the accessory before the fact, I believe it's Aguiar, after the fact, to burn the wallets. He tells Maryland to take them out into the trash. He goes to Providence to hide out, and presumably from the police. So there's a whole series of events that demonstrate a calculated effort to conduct this criminal escapades over the course of this evening, and then avoid prosecution for them, which I would say is akin to those cases in which the court has said that a jury instruction may not even be required because the evidence simply does not raise the issue of whether it be manslaughter or whether it be self-defense. This is similarly a case in which the evidence essentially, notwithstanding the opinion of the expert who testified, but because of the defendant's own admissions, there's essentially no issue of sanity left in the case.
Does it affect malice at all?
The presumption language also goes to malice. But again, I believe that the defendant's own testimony essentially directs that issue. He essentially admitted all elements of the Commonwealth's case.
There's no, I guess I'm wondering, I mean, there was no evidence by the expert that the way he was testifying, you know, this narrative of intention and non-impulsive activity is really a sign of a kind of mental illness.
I don't believe the expert testified as to that. I don't know whether the expert was in the courtroom to hear the testimony. Presumably...
Did he testify before?
He testified afterwards. The defendant's testimony starts around page 1272, and the expert testifies around page 1600. So he may not have been in the courtroom during that testimony. He may not have seen it. So I think it would be probably unfair to draw the conclusion that his omission was meaningful because of that, because we don't know that he was in the courtroom. Presumably, as a paid witness, they would have tried to limit him to the...
Now, the mental illness, I gather, was that he was a sociopath. Was that the
Yes.
only categorization?
Otherwise known as a crook, which is what the Commonwealth's witness said, though I believe that reference was struck and the jury told to disregard it.
Now, let's assume, for the sake of this argument, that there was a waiver of the appeal. Do we use the gatekeeper standard? That is, whether there's a new and substantial ground for appeal, or do we use a relief from waiver standard, which I think you mentioned in your brief, which comes from Judge Smith, which is a miscarriage of justice standard?
I would think it would be a relief from waiver because they're not, well, or maybe the real answer is that it's mixed because the issues that arose from new constitutional law should be assessed through the gatekeeper standard, whereas the ones that were foreseeable, and my brother said that that's really mostly the jury issue, that one should be assessed through the relief from waiver. Because really, the only things he could have waived were things that would have been known in 1964, June of 64.
I have a question. I probably should have asked the defense lawyer, but I didn't. The defendant in his affidavit says, after indicating all his charges and convictions, he says judgments on all of the above indictments were affirmed by the Supreme Judicial Court on April 14th, 1966.
That's in the pro se memorandum?
No, it's in the affidavit of the defendant,
Oh.
A record appendix.
Well, that has to do with how procedurally the motion for new trial came to be filed. Several years before Mr. Petetabella filed a motion for new trial, co-defendant Souza filed a motion for new trial. And Mr. Petetabella got a copy of that, and as a pro se defendant, changed his name throughout. So that is a reference to Mr. Souza's appellate original appeal. It's
I see. So there were judgments on Souza's convictions, not
Yes.
on
Yes.
this defendant's. Okay, thank you.
Can I ask sort of a larger question? I don't know that this case was unique in 1963, apart perhaps from the issue of the woman being barred as the 14th juror. What's the consequence here with regard to all other cases tried in an era in which the rights of a defendant were markedly different?
I believe, in terms of retroactivity or in terms of?
In terms of, I mean, basically, I would think almost any case that was tried in 1963 through 67 are going to have fundamental legal issues, including probably Sandstrom type
Including
issues.
Sandstrom. Many of those individuals made motions for new trials following Sandstrom in the 70s. And so there are, first of all, anyone still in prison for a 1963 crime had to have committed first-degree murder under a certain age. So we're talking about a limited subset of people. This defendant was maybe in his early 20s when he committed the crime. He's in his late 60s now.
21.
So, pardon me, 21.
That's what the defense lawyer said in the argument, 21.
So the population of people that this affects is probably small and growing smaller. However, and because of the length of the incarceration, it would almost have to be first degree
Well, if we
murder.
simply said Sandstrom is not retroactive, then that would end the problem.
Well, it depends what you think the problem is. If you say Sandstrom is not retroactive, if you say that Sandstrom is not retroactive, then it enhances the finality of 1960s convictions. Yes, I agree. Are there any further questions? If there are no further questions, then the Commonwealth would rest on its brief.